Hello, everyone. Hello, everyone. This is Curt Barone.
Brad Pinsky.
All right, and here we are for another edition of Fire Law Roundup for Halloween, October 31st of 2022. So, Brad, why don't you take us away with the cases in the order you think we ought to cover them?
Well, I'll tell you, in no particular order, we do have some scary and confusing things today, which is totally appropriate for Halloween. Let's start in Oklahoma City. I don't understand this one either. Well, let me give you the facts, pretty short facts. Paramedics from AMR and a fire truck responded to a seizure patient. You have a long list of facts on the website and the blog, but I'm going to make it very simple. He's seizing, and then he's, I think, post-ictal, and as probably everybody knows on this blog, post-ictal is you're pretty much out of it. And for some reason, they jump on this guy and handcuff him. And these are the firefighters, not the cops. And when the cops get there, they ask for the handcuffs, and I guess they handcuff him. And he, I'm not making light of this. It's almost a George Floyd type situation, and I have no idea of races or anything. I'm just saying, they're holding him down, and he can't breathe, and then he stops breathing, and he's handcuffed or hogtied. I'm not really sure which, but in any event, he is definitely restrained forcibly, according to this, and dies. So I got nothing there on why this happened.
I mean, one of the things we got to understand, we're getting the plaintiff side of this. We're not getting necessarily the city side of it, and which is typically how we roll with what we've got. So the plaintiff has laid out the case. I'm not buying that somebody is just having a medical emergency and all of a sudden firefighters just jump on them. That doesn't make sense.
Agreed.
So I'm thinking that there's got to be some sort of behavior that's precipitating the firefighters feeling the need to restrain the person. And, afterwards, who knows if there's the police on scene, who knows what the body cam footage might have picked up or what bystanders might say. But the reason why this case interests me is, and I put it in the blog, is that we're seeing many, many more cases since George Floyd's death. We're seeing many more cases of fire departments being targeted in these lawsuits, whether it's because they're getting physical. Most of them are because the fire department are getting physical with them. Some are ketamine related or sedation related. Right. Others are where the fire department didn't do a thing. They get called to the scene, but as part of government being there, they're alleging that the fire department failed to intervene. So there's a broad range of these. I have the numbers here. I think I got 62 total cases like this.
Wow.
Only 9 prior to 2016. Now my cases go back to the 1800s. The earliest case I've got is somewhere around 1860, and not a lot of cases back then. I don't mean to suggest, but there's 53 of them have been since the death of George Floyd.
Yeah, and we've covered a ton of them on this vlog where they're physically restraining. We've had some really good discussions here. Forgetting the fact this is alleged for a second, it's interesting how they try to sue, right? Because here they're alleging Fourth Amendments. I didn't see if they alleged other things like flat out assault. I'm shocked that this is all they're alleging is a Fourth Amendment, which is violation of search and seizure. So normally when the government acting as the government, and here they focus on were they acting as law enforcement, I was surprised that mattered versus, right? Because that was narrowing. Now you're not just government. We're going to talk more about this to our listeners. I know I'm confusing you, but they allege that by right to be free from search or seizure, in this case, seizure, which would like an unlawful arrest, right? The right not to be detained without probable cause, etc. They allege that by this assault, which makes sense, alleged assault, which makes sense. And then the judge kicks it on the basis that throws it out on the basis that they weren't acting as law enforcement when they did this. Have you ever seen that? I've never seen any holding like that.
Yeah, they're starting to kind of dissect what we're doing versus law enforcement. So if we're helping law enforcement restrain someone, okay, for example, we're administering ketamine so that they can get a suspect under control so they can arrest them. We're acting sort of as an agent of law enforcement. Whereas when we're administering ketamine for medical reasons, okay, or we're administering care for medical reasons, then that's different. And I think that's good for us. I think in a negligence action, and I know we haven't talked about negligence action. I think in a negligence action, it's not so big a deal. But when you're dealing with Fourth Amendment, and the issue is, are you seeking to apprehend this person? Are you seeking to arrest them? Or are you seeking to get an incompetent person to medical care? Because an incompetent person cannot consent or decline medical care. So if we determine the person doesn't have capacity, then there's a medical reason for putting them in restraints and getting them to the place. It's not a law enforcement activity. It's a medically related activity. And some of this, Brad, I see you look at, some of this is because attorneys are starting to make the argument. Back in the 60s and 70s and 80s, if the attorneys didn't make that distinction, the courts weren't going to come up with it on their own. So I think attorneys today are making those arguments that they weren't making before, necessitated by the growth of these cases. I'm sorry.
Right. And no, it's and I think the red herring, maybe if I was to use the court's view, is the handcuffs, right? If the patient had been restrained with soft restraints that, and I don't know in this jurisdiction if it's allowed, but that were allowed to be carried by the ambulance, and some jurisdictions allow soft restraints for the protection of a patient, right? And seizing, maybe not postictal, but seizing heroin, I've seen it, but soft restraints, there probably would be no question. Look, you're not, you're doing this for medical purposes. Here, I think what the judge basically says or assumes is just because you use handcuffs, which are from the police and probably only available to the police, does not mean that you are acting as law enforcement. I don't know if I personally agree with that, because, and I would have argued it this way. I would have said that you used a procedure and a technique not available or allowed to paramedics or EMTs and definitely firefighters. You brought in the tools of law enforcement, and I would have said, so you're acting outside your capacity as paramedics and firefighters, so you must have been acting as something else. So what else were you acting as? And it seems to me when I use the police's tools, I must be acting as law enforcement. Now, fine, but you take a little bit different view, which I happen to agree with, which is, okay, but what was your purpose? What was the end goal? Was my purpose to effect a citizen's arrest? Or is my purpose to protect the patient from himself? I didn't maybe have soft restraints or other means available, so I asked the police for theirs. Okay, I could see that. It begs the question, though, and I don't know the answer to this. Can the police, if the police were first on scene and they arrive to a patient, let's say who's in harm to himself, not others, but harm to himself, maybe he's trying to grab a knife to slit his wrist, something like that, and they handcuff him, is that acting medical or is that acting as law enforcement? So you got to get, same way, it's got to be evaluated. And I don't think that the police would be deemed to be acting in a medical capacity. It wouldn't be a Fourth Amendment violation, right? They're protecting him to himself in a different reason. They're not, he's incapacitated anyway. They're not restraining his liberties because he's mentally out of it anyway. So I would argue they didn't incapacitate him, but
I think
just don't see how you're splitting
my friend Jack Ryan focuses more on police. I should give him a call and see what see if there's a line of cases that sort of differentiate police behavior in terms of, are they taking someone into custody for arrest purposes, for criminal purposes, or are they taking them into custody for psychiatric, or really, and I would consider psychiatric to be medical, for medical reasons. Okay. But at any rate, in this case, it seems like the court felt that what the medics were doing here did not trigger Fourth Amendment concerns, and that Also, in addition to that, they also felt that they were entitled to qualified immunity, which the qualified immunity defense, you don't get into the merits of the case. If someone has qualified immunity, then even if they did violate their rights, even if there was a technical violation, you have immunity, so they're going to get off the hook, for any potential liability. And so the court kind of gave really two reasons for its findings, but essentially said that the firefighters are going to be dismissed from the case, and the case is going to continue against some of the other defendants, but the firefighters are out of the case, which is, I think, is good news for our friends in Oklahoma City.
Yeah. No question. And look, I'm surprised, and maybe there's more, but I'm surprised that it appears they only allege these two causes of action. And look, you wouldn't necessarily allege assault, because then you can't get to the city, because they would say, well, assaulting somebody is not in the course of their duties, so the city's not liable for it. I get why they may not have said some other things. Normally you'd see this happens all the time, breach of policies, a Monell kind of, where this always happens and the city doesn't care. Maybe they didn't have that. I don't know, but this is a really interesting case for any time a firefighter or municipal EMT restrains anybody. And I'm curious if there are other cases going the other way, that restraining somebody, could be non-medical at some point. We get some cases. We got some of the ketamine cases, in particular, Aurora, Colorado, and that whole mess up there is really focusing on the apprehension. Like, are you apprehending someone? Are you administering ketamine or using restraints so that the police can apprehend and arrest someone for a criminal act? We saw that at the playoffs. Right.
The attorneys are getting better at making these arguments. And I think that's part of it. But again, the reason why this isn't a straight medical malpractice, really a negligence action, wrongful death action, which is, I think, when things like this happened 20, 30, 40 years ago, they came up as a wrongful death negligence action. And now they're coming up, as a civil rights, is because it's so difficult to hold government liable between sovereign immunity, tort immunity caps, and other public duty doctrine, a number of other different liability barriers that people would have to prevailing. So I think many people, particularly attorneys who regularly sue police departments, usually will go after those 1983 type claims, and that's what we're seeing. And not that this is new. What we're seeing is fire departments now getting named in these 1983 cases that involve police type activity.
Right. And just before we move on to the next case, one of the first things that went through my mind, obviously, again, we don't know the facts, we know the allegations, but can you take away someone's Fourth Amendment rights if they're not aware you're doing it? Right. And this question has been answered. I don't remember the answer, but the question is, so if you don't know you're locked in a room, but I locked you in a room, are your Fourth Amendment rights taken away? And that's an actual case. I just don't remember where it comes from. But so if you are truly postictal, and look, obviously, why are we putting you in handcuffs in the first place? I have no idea. I don't get that. But if you're truly postictal and you don't know what's going on, does being in handcuffs affect your Fourth Amendment rights? Because you don't know you're in them. You don't know you're restrained. Your liberties aren't taken away, as I think how the analysis goes, because you can't exercise your liberties regardless. You're unconscious. But okay, in any event, they got off, and I think this is a very, very interesting line of thinking that people. This is not an invitation, firefighters, to start handcuffing people.
No, and I think the opposite. My advice to firefighters now is, when you are going on a run to assist the police, you've got to be very careful in terms of what you do. You can read the case and you can hear some of the comments that the firefighters allegedly told the person, and how those can be spun against you. But there was some comments that were made that found their way into the lawsuit. And our antenna's got to be up when you're going on a run. with the police and you're applying restraints, you've got to be very careful, and you need to document, do a very good job of documenting. This is not just another run. This is the type of incident that can lead to litigation very quickly in the event that something happens. Yeah.
Yeah. And what really bothers me about this is, look, we all know one absolute truth. Cops want to be firefighters. So don't act like a cop, because now you're just saying, see, firefighters want to be cops. And we know that's not true. So let's not give the cops any reason to make them think that we want to do their job. Okay. Right. Let's go to Massachusetts. This, I totally agree with this holding. Great holding. I don't know if you disagree. I think this is great holding. So here in Massachusetts, the court, after some administrative review, reverses, but the court concludes that the method of selecting the fire chief is not a bargainable topic. They do this, and I fully agree, because they said, listen, this doesn't affect the terms and conditions of anybody's employment. It's moving up and out of the union stream. You are no longer going to be in union. Your management, you're not going to be covered by the CBA, and this isn't affecting your terms and conditions of employment, so it's not bargainable. I don't know if you remember.
Let me make the argument. I agree with you. I agree with you. But let me make the other argument. Okay. And the union argument, I think, is a good one. I disagree. I agree with you. But the union's argument is, look, the only people who are eligible to become the fire chief are the 4 deputy chiefs, and they're all in the union. Right. So therefore, this affects their promotions. Promotions are a mandatory subject of collective bargaining, universally recognized as that, and therefore, they should have to bargain. Not who's going to be the chief. You don't have to bargain on who's going to be the chief, but the process. What study material is it going to be? Written exam? Is it going to be an assessment center? The process should be bargainable. So that's the union's argument.
And I swear I've seen in the last year or two cases that went the opposite way, where they said it is. Yeah, I know. But I happen to agree with it. Once you're taken out of your succession line, right, where you're not guaranteed to go, and just because you get to the highest rank of deputy chief, that's it. That's where that kind of ends. Now you're out of there completely. I happen to agree with that. It's not a term and condition of employment, but I totally see the opposite side of it. Totally see the opposite side. I just think it was a good call, but a tough call on that. But
I can see other courts, other states going in a different direction on it. But
yes. And I wondered how much of this was specifically related to Massachusetts law that could be changed by a different. Right,
100%. This is a Massachusetts decision. It has no other than persuasive value. It has no impact. It doesn't. It's not the interpretation of the National Labor Relations Act, or it's strictly Massachusetts. And I think there's some unique issues here, because, as I understand it, only those 4 deputy chiefs were eligible for this test. So this promotion, and it's not a situation where they could have gone to the outside. I think once you start saying that, well, other people would have been eligible for this, that changes the union's argument a little bit. Okay. Right. But here the union, I felt, had a pretty strong argument that, look, the only people by law, the only people who could take the test are the 4 deputies. Therefore, they're in the bargaining unit. Therefore, it should be bargainable. But the Court of Appeals said no. Now, the Massachusetts Supreme Judicial Court still has a shot at this, so if they choose to appeal it. So,
and I liked what the court said about this, about the ladder. It's not really in the promotional ladder, right? The union said, well, this is in the promotional ladder. The court said it's really not. But again,
you can argue the position. The position is in the ladder. It's obviously in the ladder. To me, the question is, you're talking about the burden on the union membership. There's 4 people in the bargaining unit who now have to compete with each other, and in that context, since they can't go outside, you can't have somebody from outside. It's got to be one of these four. These four are in the bargaining unit. You got to bargain over the process. So I can understand that process.
Definitely
and also in a department where it was different, where they could go to the outsider, they could take a retired member, whatever it may be. I think it's a little bit different.
Okay, now I'm gonna, as I normally do, I'm gonna disagree with my own court system. Let's head to New York, where the state's highest court. Now, this one I understand, but I actually disagree with. So I'm flipping. Not that anyone gives 2 cents what you and I think about, but so be it. The state, New York State's highest court, and I'll explain this, held that a provision in the civil service law is actually bargainable. Now, here's what happens, and I've used this when I was chief. When you have under the civil service law, and which is a state law that governs civil service employees, and just so everyone knows, the civil service law kind of gives you ground rules, but you can bargain them away. And that's the question here: is mandatory bargaining, right, part of this? So what this is the civil service law section 71 says that if an employee is disabled for more than a year, the employer can get rid of them, which is the right thing, right? Otherwise, you're going to keep employees around forever who are disabled. And the civil service law basically says you can terminate them. The court comes in, and now the state's highest court. I mean, this is a big deal because fewer than a 10th or 100th of the cases that are at where the Court of Appeals is asked to consider a case are ever accepted. I've had 1 accepted, 3 rejected. It is very tough. Most attorneys have never gotten a case to the Court of Appeals. It's very tough. So this is a big deal that it gets to the state's highest court. It's not automatic, as a lot of people think. I'll just keep appealing. So what the court held is that the Taylor law requires the employer and the employees, right, the union, to bargain over the process for getting rid of somebody after that year, which it screws with me a little bit, because I think, well, wait a minute, the process for termination, you're gone for a year. What process is there? Now here they said, well, we're going to get rid of you and then you can appeal it. I think that's horrible. You've constitutionally prejudged the issue, which is a different issue. How can you say, well, I'm going to make a decision, but then you can appeal my decision to who? To me? I mean, that makes no sense. We've made a decision based on nothing. And then we're going to reconsider our own decision. Not constitutional. But that said, the court comes in and says, exactly, this is a bargainable issue. The process to how this happens is bargainable. Now, the city raises a good point, which the court deals with, right? The city's like, well, wait a minute. That effectively could stop us from getting rid of people, or the process becomes too hard. It interferes with our judgment. And the court comes back and says, look, there are avenues to address that problem, but it's still bargainable. And this is now going to open up a whole Pandora's box, maybe for good, but to the unions to say, now how much of the civil service law, which sets the ground rules, is now bargainable? And look, nobody would ever disagree. Termination is a term and condition of employment, which should be bargainable. The issue here, though, is you're either gone for a year or you're not. Your doctor either says you can come back within that year or you can't. There's not a lot to be debated here, but nonetheless, the process for getting rid of them is now subject to bargaining. And
Brad, here in Rhode Island, firefighters are entitled to, we're not under workers' comp. It's analogous to workers' comp, but it's not workers' comp. But basically, the state law says that if a firefighter is injured, they're entitled to full pay and benefits for the duration of their injury. Now, that could potentially go on for 20 years, 30 years. Now, they've subsequently modified the law somewhat to say that you got to pay them if it's a work-related injury, okay? You've got to pay them until they go on the pension. So the big battle now is to push people who we've reached a conclusion they're never going to be able to come back, to get them onto the pension. What is the law in New York on that? Because if someone, and I'll give you, I had a client who hurt her shoulder, and her doctor told her she needed therapy. So she went a couple of months of therapy. That didn't work. Then he says you need surgery. She has the surgery, then goes to PT. That didn't work. Have to go to surgery again. She's up to a year now. And if the department can just like fire her, which, I mean, there's got to be some connection here with a pension or.
Well, I think that's related, but a different issue. Whether we can fire you is one thing. What benefits you're entitled to is another. In New York, we have the same thing. In New York, every employee gets, 2/3, if they're injured on the job, gets basically 2/3 of their salary, to make it easy. The fire service has this extra 1/3 where the municipality says, okay, but we're going to give you the remaining 1/3. So you're made whole for any line of duty injury. And there's tons of cases on when does it kick in or not? What was a line of duty injury? You're cleaning your car at the firehouse. Is that a line of duty injury? And that's a real case. And the courts almost always side with the firefighters. Almost everything's line of duty injury if you're at the station, right? Almost everything. So in any event, once now the municipality has to give that third. So now they're whole. And then the question is, how long, right? Does this go on forever? We can terminate you, says Civil Service Law 71. Now, I guess the process is up for debate or negotiation. But then the question is, what do you get? And almost always there's a settlement where they do a analysis of future value of what is your salary worth over your remaining years. We'll pay you.
So engine firefighters get more than ladder firefighters with future value?
They should.
No.
Are truckies even really firefighters? Anyway, so they just looked out anyway. So but
we just lost half our audience.
The process here has got to be bargained. And the interesting thing is this now great. The labor lawyer's like, woohoo, right? Open up the contract. But think about that. Nobody wants to ever open up their contract for negotiation until it comes due. Maybe they'll deal with this through a memo or something, but nobody ever, I don't think anybody, I've seen a lot of contracts. I've not seen too many that deal with the 1 year. So this was a pretty impressive, case to get there to say, okay, after 1 year, we got to talk about the process to get you out. I don't know if you're the union too, that you're going to spend a lot of money defending somebody who's out a year. As you said last week, normally they're harassing somebody who's been out of year saying, we want you gone because you're affecting my life. So I don't know how many unions are going to strive too hard to actually protect somebody who's gone a year and not coming back.
Yeah, I think they do. No, I hear they do. Here they do. Yeah. I mean, I think I can see in some places they might not, but usually because any of us could end up in that situation. It's just you go out the door and something happens and now you're recuperating, and a year just seems like a kind of a short period of time.
Yeah, in my experience, that's not what's happening here. In my experience, it's, the employee is one of those not great employees anyway, and claims he got hurt on the job while he was alone in the garage pushing a broom and picked something up. And, I tweaked my back. But somebody saw him walk in the door with a tweaked back, and maybe he did it over the weekend off the job. That's normally where I'm seeing these things come up, not a true line of duty where everybody.
But what do you do? What do you do when there is, in fact, because if you treat Mr. A, who's maybe got a legitimate line of duty injury, and now Mr. B comes along and you fire him because he's a phony, scammer, whatever you want to call him. And now Mr. B is going to say, wait a minute, you're treating me differently than you did Mr. A. What's going on?
Workers' comp. The workers' comp board is going to decide whether it's a line of duty injury or not.
Yeah.
Right. I mean, they decide, not the employer, for the most part.
And I think that's the right way to handle it. But I think if you got to have a process, and the process shouldn't, like if you're injured and we conclude that it's a line of duty injury, even if you were, one time at Providence, we had a guy, they forced all the guys who were off for an extended period of time to come back to work. And we used to have floor watch. We used to have to sit at the floor and hit the bell if there was a run, and all that floor watch stuff back in the day, right? And so this guy, what they did was they had all the light duty people come in and do floor watch. And this guy was there for about an hour, and he fell out of his chair. Like he said he was rocking back in the chair. He fell over, hurt his back. That rescue had to come and take him to the hospital, collar, backboard, the whole thing, So the scammers are out there. But how do you treat somebody like that differently than you do somebody who's legit? Because it happened at work. He did fall out of the chair, whether it really, amounted to a serious injury that warranted a year off. I don't know.
Well, once you go see Dr. Yearoff, but here's that's the point of my confusion, because workers' comp has now made the decision. They've determined that it's on the job or not. So fine, they determine it's on the job, right? It doesn't really matter, but you're entitled to benefits. But that question aside, are you entitled to your job? Well, you're injured, you can't come back. That decision's already been made. You've already been determined to be permanently, totally, or permanently partially disabled such that you can't do the job. What are we appealing? What are we negotiating?
That's different, though. Making that determination, I agree. If you make the determination that there's no chance the person's coming back, that's different. Okay. But if somebody's been off, like my client who had the shoulder surgery, her doctor felt, look, she's going to be 100%, but it's going to take 14 months, or 15 months. Right. She's going to be 100%, though. You can't fire. You're going to fire her? I mean, that's, well, I'm glad I live in Rhode Island.
Right. But that's the thing. Like, so what process? There's a medical determination. The determination's been made. You are not back by 12 months. Your doctor's not released you. I'm not sure what process. I'm sure there are some, but I'm not sure what process we're even talking about. Your doctor either said you are or you're not. If you're not back at work, if you're not released by whatever process you have, the department's doctor, your private doctor, comp doctor, independent medical exam, whatever, what are we dealing with for a process to decide, we get to fire you? In any event, I don't totally understand it, but
yeah.
So, but probably the right holding, and it doesn't matter whether I agree or not, because the state's highest court said so. But this is going to open a can of worms on, okay, now what else in the civil service law it affects terms and conditions and is bargainable, all that.
Well, I know, not to belabor this point, but in most states, you cannot bargain in a way that's going to change civil service law, but you can bargain. Like if civil service law says, you've got to promote someone who's a firefighter to lieutenant. You can't hire from the outside. That's fine. You've got to promote somebody's in your department from firefighter to lieutenant. But what's bargainable is the process. Unless civil service says this is how you have to do it, but whether it's going to be 80% written, 20% seniority, or 60% written and 20%.
That's exactly what happened here.
Physical abilities. Right. So yeah, exactly. So I think there's a difference between bargaining in a way that's going to violate civil service and bargaining for more precise, the way procedure that it's going to be done. Yeah.
Right. Agreed. And I really think that's happened here. They haven't taken benefits away or rights away from the employer. It's just how you get to those rights is now up for debate. Okay, so but that's going to open up Pandora's box and maybe good. Okay, so now let's go to Idaho. This is a really interesting one. I don't look. It's the same case we've had a million times. I'll explain it. Where, and being more generic to start, right? Somebody makes an accusation. Well, start with somebody's terminated, right? In this case, I think a volunteer firefighter in Idaho, but he's terminated. He claims I have a disability. I'm deaf or I'm hearing impaired. They say deaf, so I'm going to presume that means cannot hear a thing. All right. Now take out of this for a second, because it apparently didn't come into play whether he can meet the essential job functions as a deaf firefighter. That's not this suit, but that's what everyone's thinking. Oh, wait a minute, deaf firefighter. That's not this suit. So what this suit is, they claim, the fire department claims we terminated him for legitimate, non-discriminatory reason, being he was insubordinate. We told him stop calling 911. We told him to call the chief when you have issues. And instead of talking to everybody else in the department, which makes some sense, we gave you an avenue right to the chief, and you disobeyed the chief. And so that makes a lot of sense. And they said, right, that's why we terminated him, having nothing to do with his disability. So this is the ping pong analysis, which we've seen McDonnell Douglas a million times. If you watch our show or read the blog, you heard this, but basically it's the plaintiff has to say, right, to start the ping pong, has to say, listen, I'm a protected class and here I'm disabled and you took this action against me and it's because I'm disabled. That shifts the burden now to come forward with for the employer or the department to say, no, we didn't take, well, either you're not disabled, you're not part of protected class, or we took this reasons for actions or reasons unrelated to your disability. And then that goes back, which is where we are, to say, okay, now the plaintiff's got to prove it. Now here, this is just going to court because they tried to get rid of it, which I'm really surprised. A lawyer moved for summary judgment, which means to our viewers, the lawyer is saying, listen, there's no reason we need a jury or a judge to question or decide any facts. As a matter of the straight law, we win. That's what a motion for summary judgment is. Never happens in these discrimination types of cases. Rarely happens.
Usually it's the opposite. And the court made a point of that. Yeah. The court made a point of that. This is where the deaf firefighter's attorney argued that we should prevail as a matter of law. So we want summary judgment. Usually it's the fire department saying, we want judgment as a matter of law. The fire department didn't say that. In fact, the fire department argued the opposite, that, look, there's triable issues here. Don't rule in favor of the firefighter. We've got to have a jury listen to the facts and then make a determination.
Right. And the legal question usually is, listen, even if fire department, what you said is true, it still doesn't serve as a defense. Right. You see where motions for summary judgment are granted against the fire department, where they just don't have a defense, which even if true would protect them. That's not here. So I was very surprised, as you were, that a plaintiff's attorney would try to say there's no question of fact, because clearly there is. And right. Obviously, why were you terminated?
Obviously. The question I have is, why didn't the fire department file a motion for summary judgment? Right. Because it sounded almost like the judge was hinting at, if the fire department had, we would have found in your favor. Right. And
maybe the reason is because the lawyers get paid more if we go to trial and win than summary judgment. Well, who knows? Who knows? I'm being facetious, but not totally.
A little bit of inside baseball here. Inside the dugout.
But, yeah, well, that's what kind of happens. The lawyers say, listen, we can get rid of this and earn this little bit of money, or we can let it go to trial and earn a ridiculous amount of money. And sometimes that is true. In any event, this was the motion by the plaintiff's lawyer, and I'm surprised, but there's nothing new in this. I'm surprised that they didn't start to raise, and maybe they don't need it as well. And I haven't seen the answer, which is demurring or giving denials, saying, listen, he can't do the job, because they didn't allow him to be an interior firefighter. And what I read between the lines is he was pissed off. He didn't like it. He's probably needling the department by talking to everybody else, saying, I have the right to be an interior firefighter and you're not allowing me. That seems to be underlying this. But you would think one of the two sides would have raised it. The employer would have said, listen, you have to be able to hear a mayday. You have to be able to hear instructions, so you can't be deaf, and we can't reasonably accommodate you. They don't do that. Maybe there'll be an ADA claim associated, who knows? But there's nothing new in this. This is just somebody who's terminated and then says, but I'm disabled. And it read between the lines, it sounds like the guy's kind of a pain in the butt. Okay. And then my favorite case, this is just my favorite. I don't know what the Mormons are doing here. We're in Utah. I don't know if you have any knowledge on this, but a fire department goes to a house. There's no allegation from either side that they have the right to use this house as a training house. And if you look at the pictures, please look at your pictures if you're watching this on his blog.
I'm going to put the pictures up. Yeah.
Please do. This is a nice house. This is not a rundown hoarder piece of crap house. The department goes to this house, destroys it, uses it as a training facility, leaves. The owner comes home like, what the heck just happened to my house? And then tells the fire department, look, just pay for this. The city, just pay for this. And they don't. nice email, privacy protection. Probably you don't want to.
Hold on. I'm coming.
There you go.
There we go.
So
all right.
Scroll down. It's like the second or third picture shows the quality of this house.
That's
okay, the garage, nothing wrong with this. But look at this picture. What are they doing? This picture of the inside. There we go. Inside of the house. This is a nice house. This was not. I mean, they tore this apart. So I have no idea why. But what's crazy?
Maybe like they started a vent hole here and they didn't finish it.
Yeah, but
right there you can see they covered over there.
Yeah, but if you look, I mean, this isn't like a hoarder house. This is a nice property, apparently, and they destroy it. But that's not the crazy part. The crazy part is, look, if this was an accident, you went to the wrong house, maybe the captain said, hey, go train at 123 Main Street, and it was 123 Main Road. They break down the door. A first sign, you're probably at the wrong house when you got to break down the door to the training house. But nonetheless, they break down the door and get in and destroy the house. And yet the city won't pay for it, or whoever won't pay for it. And so the lawyer now saying, I got to sue you. I mean, he's lucky they're not calling the police, frankly.
A lot of times folks will write into me, giving me the backstory on cases, and no one's reached out to me on this one. So I mean, I'm hoping that there was some sort of a mistake, maybe even that the homeowner originally agreed to allow the house to be used, and then there was some mix up on the paperwork, or some explanation for this. Not that they just you just randomly went up to a house. It doesn't even make sense that
I'm sure this wasn't malicious, right? There was a mistake, maybe a non-defensible mistake, but a mistake. But look, in the end, this is just about, why is the homeowner being forced to sue over, unless you've got a document that says you gave us the house, and you transferred the house to us. Why isn't this just an insurance issue? I agree with what you and I were talking about before the show. This is crazy.
It should have been turned over to the insurance company, and then it's between the homeowner and the insurance company as to exactly how much damage, what's it going to cost to fix it.
Right. And frankly, it doesn't look that bad that it can't be fixed. It looks like it's blown in insulation and some drywall and a door and windows, but it's all fixable. They didn't burn it down. I just a little shocked. So anyway, I'm sure we'll get some information. And hopefully, if you're listening and you're in Utah, write to Curt. We'd love to know what really happened here.
Absolutely.
That's our 5 cases for the week.
All right. Well, I just want to remind folks that, we need some more subscribers. We're trying to get up to 1,000. I think we had 665 or 670 or so as of now. We really want to get up to 1,000. That's like an important benchmark for YouTube. So if you can help us by subscribing, that would be very much appreciated. And please click like. That helps as well. Like and share. And that's going to do it for another edition of Fire Law. I'm going to be in Boise next week on Monday, so we'll have to figure out when we're going to do. We won't be able to do it Monday, maybe do it Sunday night or whatever. But for those who are listening, so just if you're subscribed, it'll send you an email letting you know when we're going live. But probably won't be next Monday at 1:00. So all right, and that'll do it for another edition of Fire Law Roundup.